Morning, folks. My name is Jim Aslam. I'm a workers' compensation attorney in Farmington, Connecticut. And today I wanted to take a minute and talk to you about utilization review in workers' compensation cases. Essentially, utilization review is a process by which certain employers can determine whether a medical treatment that your doctor is proposing for your work injury case is an acceptable form of treatment, and therefore the insurance company has to pay it. Now, the important thing to remember in Connecticut is that utilization review does not apply to the vast majority of Connecticut workers' compensation cases. Utilization review only applies if a particular employer has set up or has applied for an approved medical panel with the State of Connecticut Workers' Compensation Commission. An employer wants to have a medical care plan. They put that plan together in the form of a proposal. They submit it to the chairman's office in Hartford. The plan is reviewed, and if it's appropriate and it meets the needs of the employer and the employees who may be injured in the course of their employment, then in due course that medical care plan is approved. By and large, only the very largest of employers have those types of plans in place, and for many of you, it's not going to have any impact at all. Now, if a medical care plan does apply to a particular employer, that's where utilization review may come in. If your doctor, for example, is suggesting that you need a round of physical therapy for your shoulder injury, and you've already had 6 or 7 physical therapy sessions and you haven't had any improvement, the doctor says, I think I'd like to try 8 more physical therapy sessions. So what happens then is that proposal or that request for 8 more physical therapy sessions is submitted to utilization review. They take a look at it, and based upon your condition, they review your medical records. Based upon your condition and a set of guidelines that they've established, they either give it a thumbs up or a thumbs down. Now, if they give it a thumbs down, they're going to send a letter to you and your doctor saying that this proposal for the 8 additional physical therapy sessions has been denied. There is an appeal period. Now, what happens is utilization review has to reach out and contact your doctor and say, in this instance, our plan is to deny the request for 8 additional physical therapy sessions for Mr. Jones. The doctor then has 48 hours to pick up the phone, speak to somebody at UR, and make the case as to why they think that those 8 additional physical therapy sessions are necessary. And assuming that happens, 9 times out of 10, utilization review is going to listen to what your doctor says, and they're going to approve the additional form of treatment. The problem arises, and unfortunately it's fairly common, where somebody from your doctor's office doesn't return the call. They're in surgery or they're busy or whatever happens, and the 48 hours go by after the treatment is denied and they don't reach out. In that case, utilization review's decision is final, and that's unfortunate. People then come to us and say, my doctor is requesting 8 additional physical therapy sessions, and the insurance company is not approving it. In that instance, they bring us this utilization review denial letter, and unfortunately, in that instance, if the doctor hasn't appealed it in a timely manner, then the employee may be stuck. There's absolutely no mechanism in the Workers' Compensation Commission to override that utilization review denial. So simply put, if your employer has this managed care plan and utilization review denies a proposed treatment, and after the appeal process that denial still stands, the Workers' Comp Commission can't go in there and say to your employer's insurance company, you know what, I think you really do need to approve this treatment. So it creates a very, very difficult situation. That's kind of putting it simply, and there are some legal mechanisms where you might be able to appeal that UR denial. But 9 times out of 10, when they say no and your doctor hasn't taken steps to handle it on that initial phone call, you're really behind the 8 ball, and it becomes a lot more difficult to get that treatment paid for through workers' compensation. So there's a couple of takeaways. Number one, if your doctor is looking for a particular form of treatment and you're aware that your employer has a managed care plan, I think you want to let the doctor know that this is going to be submitted to utilization review, and they should be on the lookout for a telephone call to justify why it is that you need this proposed treatment, whether it's additional physical therapy, whether it's epidural steroid injections, whether it's surgery, whatever it happens to be. All of those things go through UR, and in many instances UR is going to deny those on the initial application, and the doctor's going to have to go through the appeal process. So that's number one. The doctor really needs to be aware that this is out here, and you've got to convince them to work with you within that UR system to get you the treatment you need. The other takeaway from this is that utilization review is in fact very rare. There are probably, I don't know, 30 or 40 employers in the state of Connecticut that have approved managed care plans. And if your employer does not have an approved managed care plan that's been registered with the chairman's office, then the utilization review doesn't apply. The Workers' Compensation Commission has jurisdiction over determining what medical treatment is going to be reasonable and appropriate for you in your particular case. So that's the other interesting thing we see sometimes, is that our clients will get a utilization review denial letter, and we'll take a look at it, and the employer will be Bob's Florist or Tom's Bus Lines or something like that, and we know full well that that particular employer does not have an approved managed care plan. You can find out whether your employer has one or not by calling the chairman's office in Hartford. They do maintain a list, but a lot of times they try to fool you, and they send you out this UR denial letter in the case of an employer that doesn't in fact have an approved managed care plan. In that case, the utilization review denial is meaningless. The Workers' Compensation Commission does have jurisdiction over your medical treatment, and the commissioner can make that decision for you. You simply have to ask, and 9 times out of 10 that's going to be approved. So that's kind of the story about managed care plans. If you have any questions about that, and it's a bit of a complicated subject, and I'm happy to talk to you about it, feel free to reach out to us. We're in Farmington. We can be reached at 860-523-8783. You're welcome to visit our website. There's a lot of good information there. It's www.aspelllaw.com. We have a Facebook group, Ask a Connecticut Workers' Compensation Attorney. You can communicate with us there. If you like this video and you found it helpful, we do have a whole series on Connecticut workers' compensation topics. Feel free to hit subscribe, and I'd appreciate it if you hit the like button. And again, we're here for you. If you have any questions, just reach out at any time. Hope you have a great day and stay safe. Thanks.